Would you like to? No, I think probably, I mean, I for one would not be able to answer it offhand, except that to say that the commission orders have been there on brownfield JVs. But yes, I think let's have a further look at it and see as to how this can be addressed. Samir, would you like to say something on this? Any other hand being raised? Yes, Mars, please.
So my question, I think I have addressed it earlier also with you directly. Now I am asking, since the Europeans are here, our law has been amended in 2007 when 43A was introduced, when this mandatory regime was introduced for the first time. As you said that any belated filing is gun jumping. Is it the view of the Commission? The gun jumping is, to my mind, is when a transaction has been consummated, whereas belated filing, the parties have not consummated the transaction. It is only a bona fide mistake perhaps, because it's a 30 days window only. So what the Commission view is 43A overlap, gun jumping and belated?
Well, I think the decisional practice of the Commission, of course, is very clear because, like I said, there's 7-8 orders in which the Commission, there have been certain cases in which it's been consummated, and other cases where, after having come to know, I mean, through media scanning and otherwise, to publication that so and so combination is in the process or had taken. I mean, of course, taken place, been consummated, then of course we have. But where we've asked them to file under 21, it's not been consummated, then we've been taking a whole lot of factors. In fact, you'll find that of late, the penalties have been very minimal. We've been seeing that what have been the mitigating factors. And the Commission has not gone overboard in trying to sort of levy very heavy penalties. I am yet to come across a case where the parties have on their own come to the Commission and said that, well, we were 30 days late beyond 30 days. I don't think there's been any such filing before the Commission till now.
No, it's not the question of what the facts are. I'm talking about the principles. Because in case of a belated filing, if the parties have not consummated the deal, but has come either by a notice of the CCI or before the deal has been consummated. To my mind, the principle is there has to be a distinction between the two.
Oh, absolutely. I think, like I said, the Commission's orders are very clear. Where it's been consummated, the penalties have been one, and where it's not been consummated, the penalties have been very insignificant. I think.
Judgment of Compet already on this issue, what Manas is raising in the soil fault case.
Yeah.
The Commission, Compet has very clearly spelled out the law. Yes, that should be the law as of now.
Okay. Any other hand being raised? Yes, please.
Good afternoon, everybody. I just had a question in relation to gun jumping itself. And the argument that gun jumping should only be prosecuted in cases where the parties have the decision, can influence each other's decisions. In that line, there is some clarifications in relation to recent Commission practice, specifically in relation to issues where arguably there is no influence being exercised by the parties, and for instance, putting the money in an escrow, and it is refundable. In such kind of situations, even though the CCI has not given an approval, would such cases also be considered?
Yeah, that's a particular case. I think that's the public purchase, which I think Samir mentioned. I think that's a okay. Anyway, the Commission's orders are there, and what the Commission thought or felt is what went into it. So, I mean, I won't be able to, and I don't think I would wish to comment on each and every Commission's orders per se.
So, if I can, I think if I understand your question, it's basically that part of not jumping the gun is obviously not not making payment. So, if Party A is buying Party B, until CCI gives its approval, consideration for that and
I think that's very clear. Consideration doesn't matter at all. If you're buying one and you're able to sort of excise influence, and that is what the Commission would look at.
So if I think the sequitur to that answer would be, sir, that if you are paying but for example, the payment amount is held in escrow, and therefore there is no right or obligation that you as the purchaser is able to exercise. Therefore, it would not be gun jumping.
No, I don't think that could be a security at all. It would work the other way as well,
Okay.
because the intention is very clear. Any question on this side? I think then I probably tea time and coffee time and okay. I think that's probably the last now.
Thank you. I'm Vinay. I'm the Dua Associates. Sir, my question is gun jumping relating to not filing of notices governed by Section 43A. So there is a penalty for gun jumping when filing is not done. But when filing is done, but integration is done before CCI gives the approval or gives the decision, for that penalty is not prescribed under the Act. 43A does not.
No, what does 43A say? That when the notice is not filed under 6(2),
Correct.
right? And the notice is required to be filed within 30 days. Now, if it is not filed under 6(2) within 30 days of the agreement or the other document, then that one, the commission has been taking it as gun jumping.
Right, sir. So, but filing has been done, but commission is looking into the transaction. But
No, but the filing has been done in time,
Yeah, in
right?
time, correct.
Okay.
And the commission is looking into the transaction, and the parties consummate by getting into the integration of activities and all. So in that scenario, Section 43 cannot be.
Well, I don't think that would be totally true, because if they started integrating, what are they integrating for? No, because there's one point which Samir had said that, well, if they start discussing their post-merger plans, that's one thing. But integrating into each other's activities is definitely not the same. I mean, the point that you're saying integrate, I mean, what would integrate mean? I mean,
Forming the sales teams and how they will be actually they will be doing the activities and appointing the.
Well, I think, you see, it can't be sort of answered offhand. One would probably, commission would need to look at what exactly it is that they are integrating all about. Thank you so much then to the audience, and my thanks to the panelists. And I hope the discussion, which I personally feel to be quite interesting, we would, like I said at the very beginning, that this is extremely timely for the commission, and a lot of issues that have been raised, and I must be quite candid in confessing that the commission on its own also has been discussing these within the commission, and on a number of issues it does feel that, well, we need to come out with further detailed guidance notes, so as to bring in some sort of consistency and transparency in what the way Commission looks at these matters, and there's, I think, understanding, clarity among the parties as well. So thank you for these words, and I think if we have to move on for coffee now and vacate this room for the other discussion. Thank you.